The Honorable John N. Harris, Judge presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. As the marshal indicated, I'm Judge Harris, joined on the panel this morning by Judge Eisnagel and Judge McIver. Just a reminder to you all, the proceedings today are being recorded. They're also being live streamed on YouTube. If you have any your cell phones or any other noise-making devices on you, please go ahead and make sure those are silenced or turned off at this time so they don't interrupt the proceedings. Two cases we're going to do here in the courtroom today. The first one is case 22-2254, Carol Albert and Stephen Albert versus Deanna Woodall. All right, each side has 20 minutes for the argument. Appellant can reserve as much of that as you would like for rebuttal. The default is 5 minutes. If you would like something other than that, please let me know and we'll try to accommodate that. It's time if you are ready, sir, you may proceed.
Thank you, Your Honor. My name is Michael DeLugo from the law firm of Wicker Smith in Orlando. May it please the court. I represent the Alberts in this appeal. This arises out of a motor vehicle accident that took place in 2012. And before I go any further, actually, I'd like to reserve 3 minutes for my rebuttal. Thank you. The lawsuit was filed in 2015, and the trial took place in July of 2022. Final judgment was entered in favor of Ms. Woodall in the amount of $505,175.66 after the jury ruled in favor of Ms. Woodall. There was a case management order that had been entered prior to trial, and that indicated that all fact and expert discovery had to be completed by no later than 15 days prior to the commencement of the trial. During the course of the testimony of Ms. Woodall, she was asked a question with regard to whether she had applied for or sought employment at a pawn shop. Perfectly reasonable question to ask in a case in which she is making a claim for wage loss. However, her response was that not only had she gone to the pawn shop, but was in potentially seeking employment, but that she had sold family jewelry in order to pay her bills. And there was an objection that was raised contemporaneously with that testimony, stating that you can't testify, a witness cannot testify, or a party cannot testify as to their poverty, which is exactly what that was. And that wasn't information that was elicited from the question that was asked. The question that was asked was going directly to her wage loss claim, which is appropriate. But she responded by testifying that she was actually pawning her family jewelry in order to pay her bills. And so that was inappropriate, and that was timely objected to. At the beginning of, or during the course of trial, counsel for Ms. Woodall announced that she was withdrawing one of her witnesses, Dr. Bohm. The trial went forward from that point on. And then later in the trial, the counsel announced that he was considering actually playing the testimony of Dr. Bohm's deposition in rebuttal. And there was an objection that was raised to that. And ultimately, the trial court ruled against the defense and allowed the video deposition of Dr. Bohm to be presented. The first issue that was raised in appeal goes to testimony that was elicited from Dr. Nizam Razak, who during the course of cross-examination had confirmed that he had not reviewed a 2013 EMG radiology study or nerve conduction study, and that if he had been presented that, he would have reviewed it. That was all that was elicited during cross-examination. Then during the course of redirect, Ms. Woodall's counsel excuse me, sought to elicit testimony from Dr. Razak by actually allowing him to review the EMG study that he had not reviewed prior to trial. And there was...
2013 one.
That's correct, yeah. That was a mistake in my brief. That was not, I referenced a 2010. And Ms. Woodall's counsel corrected me on that. That was a 2013.
In evidence.
That is correct. It was in evidence, but Dr. Razak had not reviewed it prior to trial. He actually reviewed it on the stand and gave testimony during the course of redirect where counsel asked him whether the review of that 2013 EMG study had changed his opinions, and he said, no, my opinions remain the same. So in effect, Dr. Razak was allowed to review the EMG study during the course of trial and then was allowed to bolster his testimony that he had given. And that is inappropriate under Binger versus King Pest Control. You can't have experts or testifying witnesses reviewing things, or radiology studies specifically, that they had not reviewed during the course or prior to trial, prior to their depositions. The idea of...
They can't do that if it changes their testimony. Does Binger apply if it just bolsters their testimony?
It does, and the Gorin Gold case stands for that proposition. I'm sorry, Gorin Gold. It apply, and I think that's the arguments on either side in this case is that Ms. Woodall is saying, well, it didn't change his testimony, so how are you prejudiced? And our response is, Gorin Gold doesn't just stand for the proposition that you can't show a witness new radiology studies that will change their testimony. You also can't use that, that newly reviewed evidence to bolster their testimony. And both the Gorin Gold case and the previous case of the 4th District in Grau versus Branham both specifically use the word bolster. You cannot do that in order to bolster witnesses' testimony. And so that...
So, counsel, you don't have a problem with the fact that it was reviewed during trial and then the statement that this doesn't change my analysis at all. That's fine, right?
No, that's not fine. My point is...
Maybe I misunderstood. Didn't your side introduce this issue during the examination? In a very limited way. Right. I understand. But you raised it, right?
That is correct.
And why'd you raise it?
We raised it because we wanted to point out the fact that the witness had not reviewed all of the relevant radiology studies.
You thought it went to the credibility, right? Of
correct.
The witness, right. So at that point, once you raise it, this is not a situation where you're just silent on the issue and then they go and say, hey, let's throw in something else that they don't know is coming. I mean, you teed this up in a way.
We did tee it up, but this is not a case of invited error. This is a case where we simply confirmed with the witness that he had not reviewed the EMG, and that was it. Mm-hmm. That was the extent of it. So that does not open the door to allowing the other side.
Why doesn't that open the door?
Because all we're doing is establishing that he had not reviewed it.
Right.
And that's
for the purpose
of saying that our witness
going
has
to credibility. Right.
Correct.
So I guess at that point, when you sort of go down that path, at minimum, why is it inappropriate for them to say, okay, we'll take a look at it. Does it change your opinion? Because
that goes against the Gorin Gold opinion, that goes against Grau versus Branham, and ultimately it goes against Binger, because Binger prohibits witnesses from reviewing new things.
I don't think Binger is directly on point, is it?
I wouldn't say it's directly on point, but
right.
the whole basis of Binger is you can't have surprise at trial. And surprise specifically that would prejudice.
Did one side sort of introduce the issue and tee it up, and then the other side simply responded? Is that what happened there?
Well, what our argument is that we have a right to argue to the jury that the plaintiff's witness did not review this particular piece of radiology, this EMG, and our witness did. And therefore, our witness's testimony is more complete. And that is something for the jury to consider as they are deliberating. And we have the right, when we're going into trial, knowing that Dr. Razak had not reviewed the EMG, to present that to the jury and to make that argument in closing. And that the trial judge's ruling took that away from us. And that was something that, that was a trial strategy that we were going to present. And in the middle of trial, that was changed. That changed the landscape of the trial. And that's what Binger proscribes. And so I'm not saying that factually Binger is right on point. I'm saying that the whole point of Binger, in a general sense, is that you cannot have surprise at trial. You cannot have a trial by ambush because that prejudices the other side.
I guess I just...
Sorry.
Go ahead.
I'm sorry, I didn't get this from the record, but how long did Dr. Razek spend reviewing the 2013 EMG?
It's not clear from the record. It's one of those where the transcript says the document is handed.
Was he sitting there on the stand for an hour reading the thing, or was it a cursory review?
I don't know the answer to that. I don't think the record really clearly establishes that. So I can't sit here and say it was 5 minutes or 60 minutes or 30 seconds. I just don't know.
Okay.
But we do feel that the...
I guess, counsel, so is it really ambush when you introduce the concept and they're simply responding? Is that really
It is,
ambush?
because the concept that we're introducing is that Dr. Razek did not review this study.
No, I understand that you wanted to attack his credibility. I get that. But, I mean, is that the same thing? Is that ambush, though, right? I mean, ambush doesn't feel like the traditional ambush in a traditional sense, does it?
It does to me, because the witness is reviewing something for the first time at trial. He certainly had access to it. Counsel could have given it to him during the course of, during the 5 years or however long this case had been pending prior to the case going to trial.
I mean, let's take a situation like this. Let's say, sometimes cases have massive, massive records, right? And there are just thousands upon thousands of documents. What if one side just says, well, let's go find a document in the record, in this massive record, that's completely irrelevant to the opinion, but we're going to make a big point that this expert didn't review it. Are you telling me that then when on the other side they can't say, look at this document, is that irrelevant? That's entirely irrelevant. It doesn't change a thing. Doesn't that, what you're telling us, doesn't that open the door to that sort of gamesmanship? And if not, why not?
Because the key word in your hypothetical is irrelevant. Mm-hmm. This was relevant. This was a document that...
No. So you would say, well, the difference is if we can establish that the document is entirely irrelevant, okay, then the rule you're proposing wouldn't apply.
If it's entirely irrelevant, then I would agree. However, in this case, Dr. Razek looked at the document and used that review during trial to bolster his testimony, and that is where we feel that the trial court abused her discretion in allowing that to happen. This was not a completely irrelevant document. This was a document that our witness relied on, and that we... So it's not so you're not proposing a bright line rule? I'm not proposing...
We would need to look at the document and say, well, I mean, how relevant is this document, right?
I don't feel...
Some documents are very relevant, some are a little relevant. Where would we...
I'm not proposing anything new. This is something that the Gurr Gold and Grau versus Branham courts have already said, that you can't have witnesses...
Hold on. They said that irrelevant documents are fine to review for the first time at trial and opine on, but
no.
Relevant documents are not? They said that?
No, they did not say that. I don't think there's any case that I'm aware of...
I'm not aware of one either.
...that talks about showing irrelevant documents to witnesses in an attempt to impeach them or an attempt to discredit them. But that's not this case. This case is different because this EMG is relevant, and in fact, Dr. Razek said that this confirms his opinion, which in effect has the effect of bolstering his opinion. Mm-hmm. And so we feel that the trial judge's allowance of that happening constituted an abuse of discretion. The other two issues...
Does it really bolster his opinion in the manner in which you were impeaching it? You were saying you didn't look at the 2013 EMG. Ours did. Our expert is more thorough. They looked at all of the information. You didn't look at all of the information. If you just did it right here on the stand, aren't you still making that same claim that in his initial formation of his opinion, he didn't review all the material? How is your impeachment undercut by that?
We have a right to know going into trial who's reviewed what and what arguments we're going to make, and the witnesses can't change the playing field during the course of trial.
I assume you knew, or you wouldn't have asked him if he had reviewed it, right? You don't ask the question you don't know the answer to.
That is correct. Trial counsel knew the answer.
So you weren't being blindsided?
No, we weren't being blindsided until the judge allowed the witness to cure the problem. So that's the issue in this case.
Does he cure the problem when the problem that you're laying out is you weren't fully prepared. Your opinion was not based upon all of the facts when you gave it.
And our position is you can't fix that during the course of trial. And that's what, in a general sense, that's how Binger applies, and that's what the Goren-Gold case stands for. And Goren-Gold, even though the Goren-Gold case is distinguishable in the sense that it was a new opinion that was generated as a result of the review of the radiographic study, our position is that whether it's changing your opinion or simply bolstering your opinion, it makes no difference. It's not
Let me change
allowable.
my hypothetical a little bit. What if, in this 20,000-page record hypothetical case, right, let's say there's 1,500 pages of relevant stuff. We don't expect an expert to review. What if they review 1,499 of those pages, but one of the pages that is relevant, they don't review? Are you allowed to go and just pound them during trial for not reviewing this one relevant document, and they're not allowed to then look at it and say, hey, this is the same thing as all the stuff I already heard. This doesn't change a thing. Why can you do that, and they don't get a chance to take a look at it? That's
all about getting prepared for trial.
So essentially gamesmanship is what we're looking for here?
No. We're not looking for gamesmanship at all.
Is that not gamesmanship?
No, it's not,
when you pick out
Your Honor.
the one document that's relevant that they didn't review?
I think your hypothetical is a little bit extreme. And
Well,
it's
it
not
may be, but lawyers can sometimes be extreme, counsel.
That's true. Hopefully not appellate lawyers, but I know trial lawyers sometimes are. But it is our position, even in your hypothetical, if there is one page out of 1,500 that the witness did not review, then the other side should be able to point that out and make that argument to the jury. And
Without response.
And it should not be curable during the course of trial. That's what Goren-Gold stands for. That's what Grau versus Branham stands for. And that's what, in a general sense, I realize that Binger is not on all fours, but the general idea is that you cannot have surprise at trial. And that was a surprise because the witness had not reviewed the document prior to trial when he had the opportunity to, but counsel did not give him that record. You can't fix that during trial. The third issue that we have raised in our brief has to do with the witness testifying as to her poverty. We feel it was an abuse of discretion to allow that to occur. And the second issue had to do with the withdrawal of Dr. Bohm during the course of trial and then turning around and saying, no, we're going to call him in our rebuttal case. We feel that both of those decisions by the trial judge constituted an abuse of discretion and warrant a new trial on all issues. And if the court has no further questions, I would like to reserve the remainder of my time for rebuttal.
Okay, thank you.
Thank you, Your Honor.
All right, counsel for appellee, you may proceed.
Thank you, Your Honor. May it please the court, Richard Dellinger and Michelle Stein, Logan Young on behalf of Deanna Woodall, the appellee in this case. Your Honors, this case was tried over the course of 5 days. It took 8 years for my client to get to trial. It was tried in front of the jury from July 11, 2022 through July 15 of 2022, and the jury reached their verdict. The EMG study that has been discussed in detail today was stipulated into evidence. It was Exhibit 13 that was stipulated and agreed to by all parties.
Why is that relevant, counsel? I mean, if the expert didn't rely on it, why does it matter that it was in evidence?
Because the expert was being asked to comment on something that was already in evidence. In this case, there's no surprise. It's it's the Binger factors.
Well, except for that, I mean, it wasn't part of the expert opinion that they thought they were going to get, right, walking into trial.
Yes, it was not part of the expert opinion. In fact, he testified consistently with what he had told, what Dr. Razak had told the appellants that he would testify during deposition. In that regard, this is completely consistent with Binger. On direct examination, the Dr. Razak testified completely consistent with all the disclosures to date, with all the discovery to date, and there is no Binger violation, there's no discovery. The key distinction between this case and the Goren-Gold case and the Grau case. In the Grau case, there were medical examinations that were done during the course of trial, and the witness in that case testified at trial for the first time in direct examination about 2 medical examinations that he did during the course of a medical malpractice trial. Brand new evidence during direct examination. Different here. This was raised in cross-examination and then addressed during redirect examination. In Gould, it was an MRI study, a prior MRI study that the witness had testified he had not reviewed during his discovery deposition, and then before testifying on direct examination, the witness in Gould, a treating doctor, had reviewed that MRI study and provided brand new opinions during the course of direct examination. Complete surprise and complete violation of Binger. That is different here. That is different here. In direct examination, the witness stayed away from that prior EMG study, even though the EMG was in evidence. He completely stayed away from it. And when the defense raised that issue, when they raised that issue in cross-examination, we objected because it had not been addressed. When the objection was overruled, the witness was allowed to testify about it, and so we then asked him about the document that they raised. The Binger factors requires surprise, unfair gamesmanship, something new. That's not the case here. They raised it. They brought it on themselves. They brought up the issue during cross-examination. If you put a witness on the stand, he testified completely consistent with all his disclosures, everything that's required by Binger, and there's no unfair surprise to them, no violation of Binger. Your Honor, during the course of this trial, all of the witnesses that testified have been deposed, and over the course of 8 years, they had an opportunity to get all the opinions. Dr. Boehm had provided a discovery deposition before his trial deposition was taken, and that trial deposition was presented to the jury by agreement. By agreement. The defense lawyer in that case, the defense lawyer in proceedings below, indicated that he may object. He needed to, if you look at the record, he indicated, I really don't know, I have to take a look at the authority. That was the full extent of his objection regarding Dr. Boehm's potential rebuttal testimony. That was it. I really don't know. This is on the record, page 4325. 4325. I really don't know. I'd have to take a look at it. Then when the testimony was finally presented in front of the jury, the judge made it clear, Senior Judge Dawn Fields made it clear to the jury that this was by agreement, that this rebuttal testimony was being presented by agreement. Your Honors, that is a waiver. Any argument here that there was some sort of objection was waived at the proceedings below. There's no fundamental error with regard to allowing Dr. Boehm's testimony to be provided to the jury. With regard to the financial status of the parties, the testimony in the underlying proceedings was a single reference to the witness pawning her jewelry when being asked about her wage loss claims. A single reference to the witness pawning her jewelry because she couldn't afford to pay her bills. The Baldamente case has a footnote, footnote 16 in Baldamente. It says, any error with regard to the financial status of the parties is harmless where the record otherwise contains enough properly admitted evidence from which the jury could figure out the relative economic status of the parties. That's footnote 16 of Baldamente. The evidence in the underlying proceeding is that Ms. Woodall drove a Chevy Impala, that the defendant drove an Audi, that Ms. Woodall was a single mother, that she was working 2 to 3 jobs, that she was bartending, that she was doing makeup and waiting tables, and that she was making less than $700 a week. There was a distinction between the parties with regard to their financial status, and because all of that evidence below established it, the footnote in Baldamente would apply. To the extent that there's any error in that single reference to her pawning her jewelry, that would be harmless error under the footnote of Baldamente. And we submit to Your Honor that there is no evidence because that issue was only addressed once in the underlying proceeding. It was a response to a question. There was an objection. The objection was overruled. There was no request for a limiting instruction at all by the defense, and we never raised it again. It never came up. We didn't address it. The appellees, forgive me, I was trial counsel as well. The appellees never addressed this issue at all during the underlying proceedings. At all. Never came up. You make a good point about the documents. Is it fair to show a witness a document that they might have, Judge Eisnagel, you make a good point about the document issue. Is it fair to show a witness a document that they may or may not have reviewed and then try to use that as a weapon against them? And frankly, it's not. In this case, the defense, if you read the record, you can see that we were hamstrung between case law which says if you're going to have a treating doctor testify, you can't provide the treating doctor with all the prior records, because then it would be a violation of the expert rules. Worley, we would violate the expert rules if we did those things. So in this case, the treating doctor just testified about what he had in his file, what he used to treat the patient. And in this case, because they used a document that was in evidence, we had the ability to cross-examine him on it. There was another point that was made. I believe it was Judge McIver made a good point about whether this, how long the witness reviewed the document, how long Dr. Razak reviewed the document. I was there. The record reflects that the document was raised in cross-examination, wasn't shown to him. On redirect, the document was raised. Senior Judge Dawn Fields took the jury out and allowed the parties an opportunity to show the witness the document fairly briefly. The witness looked at the document. It's not a radiological study. It's actually an EKG study, which is just a report. He gave his opinion. The judge allowed it, said they opened the door, and then the jury was allowed back in. The questioning of him was, according to the record, that's the record below, was 10 minutes or less, and he provided his opinions. So, Judge McIver, you make the point that they still have the ability to cross-examine the witness on the point that this was just a very superficial review, that he didn't really review it in any level of detail. Having Dr. Razak review that EKG study did not impact their ability to cross-examine him on the superficialness of that review, because it was very, very quick in front of the jury in 10 minutes or less. In closing, unless there's any questions, I think I've covered the three issues, but I do want to remind the court of the standard of review. In this case, we had a trial judge, Senior Judge Dawn Fields, who tried this case over the course of 5 days in front of a jury and had access to all of the evidence. And great deference is to be given to trial courts who have superior vantage point, having reviewed all the evidence and all the proceedings in this case. In this case, there was no abuse of discretion in allowing the evidence, whether it be the EKG study on cross-examination and then redirect the single reference to pawning or jewelry that was never addressed again, and the agreed-upon rebuttal testimony of Dr. Boehm, agreed upon, according to the record. Any error that took place in the court below would have been harmless. That testimony about the jewelry, according to the battlementi footnote 16, would be harmless given the testimony that the jury already had about the financial status of the parties. So, Your Honors, the case should not be reversed. The judgment should stand. Thank you, Your Honor.
Thank you, counsel. All right, just under 4 minutes.
Thank you, Your Honor. I would like to draw the court's attention to the Gould opinion. That citation is 277 Southern 3rd 600 at page 603 of that opinion. The court writes, appellee was obviously attempting to bolster his case by showing Dr. Myers the 2010 MRI after appellants had relied on the cutoff of discovery and the commencement of trial. Okay, that sentence is clear that it is not just a change in a testimony of a witness by showing them something new that is out of bounds. It is the effort to bolster the testimony of that witness by showing that witness a document that they had not reviewed prior to trial. And so, talking about how, well, Dr. Razak didn't change his opinion as a result of reviewing the EMG during trial is simply misses the point. The point is that you cannot have a witness review things for the first time while they're on the stand and give opinion testimony regarding the review of that document. And that's why we feel that that was an abuse of discretion, and that's why we feel that the case should be reversed and remanded for a new trial on all issues. And with that, I'm going to rely on the contents of my briefs. Thank you.
All right, thank you both very much.